Good morning. My name is Glenn Katon. I'm an attorney with the American Civil Liberties Union of Florida. We are the largest civil liberties organization in the state, and we oppose the proposal that's before the City Council today. We oppose it because it seeks to eliminate free speech, assembly rights that are central to our democracy. The ability to hold up signs, to speak, to assemble, to pass out leaflets to passersby. Those are the values, and I'm not overstating this point. These are the values that people fight and die for, and today people are fighting and dying for to preserve these democratic principles. The people of St. Petersburg have entrusted you with the power to preserve those rights. We're not talking about eliminating all of them. In the entire downtown, but we're talking about eliminating a meaningful portion of it. And the people who are out there peacefully demonstrating and peacefully trying to engage people and talking about important political issues have made that point far better than I ever could. I want to talk to you for a minute about a letter that I sent to all of you, Chairman Danner, the mayor, and all the members of the City Council on August 5th. And in addition to stating the civil liberties and free speech reasons that we oppose this proposal, I set out a series of 4 cases, legal cases, that all, in a nutshell, say you can't do this and keep out the protesters. I've been litigating in federal court for 17 years. It's my honest opinion that this will not work. We're litigating a similar issue in another part of the state. Mr. Wolf refers to this one case in the 10th Circuit. I'm not sure which case he's talking about. If he's talking about the case I cited in my letter, which was the First Unitarian Church versus Salt Lake City, the holding of that case, what the court decided was that they could not squelch the easement rights of the people to use that right-of-way for First Amendment protected activity. The holding of the case, if it's the same case, is exactly the opposite of what Mr. Wolf represented to you. He also didn't mention the 2 other United States Court of Appeals cases that I cited in my letter. One of them involved the Venetian Casino in Las Vegas, where they widened the street. They took the sidewalk in, privately owned by Venetian Casino. They said, we don't want protesters out there. The union was protesting there. They said it's now a private sidewalk. We hold title. The court said no. If you're talking about the periphery of a block, whether you call it private or you call it public, these First Amendment rights are attached to it for good. And the 6th Circuit case, United Church of Christ versus Gateway Economic Development, says the same thing. It had to do with the arena where the Cleveland Cavaliers play, the sidewalk surrounding it, privately owned. The arena said, we don't want demonstrators, we don't want people picketing, what have you. The court said, you cannot do that to a sidewalk within the urban grid. If we challenge it, we will win. And I'll tell you what, don't even trust me on that. Just worry about the attorney's fees that the city won't cover.
Thank you. Next speaker. Okay. No, we're not going to applaud. Please, let's be respectful. Next speaker, please.